Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Okay, so this is part 2 on commercial leases, and we're jumping right back in where we left off. So starting with number 8, let's talk about maintenance and repairs. Your lease should clearly state which party is responsible for the maintenance and repairs of your rental property. Typically, the landlord should be responsible for the maintenance of the common areas, the structure of the property, and the building systems, such as the electrical, the plumbing, and the HVAC to the point where it enters the premises. Your landlord should also be responsible for pest control. The tenant is usually responsible for the maintenance of the interior areas of the property. However, you need to read the lease terms to determine who is responsible for what. Why is this? Because the landlord may state that they're not responsible for anything. And this is generally allowable because parties are free to enter into their own contracts. As I mentioned in part 1, commercial leases are not governed as strictly as residential leases. For example, in a residential lease, a tenant cannot waive its right to live in a habitable place. So the landlord cannot put a provision in the lease that states that the tenant is responsible for all repairs. And if the landlord did do such a thing, a court would invalidate that section of the lease. However, this is not the case for commercial leases. What you've signed is what you've agreed to and what will generally be upheld. So make sure you pay attention to who's responsible for certain repairs and maintenance. One thing I want to add about maintenance and repairs in comparing residential leases to commercial leases is that in most, if not all residential leases, a tenant has a legal right to abate or subtract cost of certain repairs if the landlord does not repair a certain issue in a reasonable amount of time. That is not a right in a commercial lease, but it is definitely something that you could negotiate into your lease between you and your landlord. Now, this can be an uphill battle for tenants to negotiate because in most commercial leases, you are leasing the right to the space. Nothing more, nothing less. But in some states, a tenant could claim that the landlord's failure to repair something critical renders the property as unfit for the purpose for which it was leased, and the law sometimes calls that constructive eviction. Now, be aware, constructive eviction is very specific, so you can't just start running around claiming that your landlord constructively evicted you to get out of a lease or to allow for damages in a lease. But I mention it so that you know it exists. Enough about maintenance and repairs. Number 9, assignments and subleasing. With assignments and subleasing, you just need to understand the conditions that may or may not allow for another party to take over the lease if you have to leave the lease early. Number 10, insurance requirements. A commercial lease will generally allow the tenant to obtain liability insurance that covers personal injuries and or damage to the property. If your lease requires it, then not having insurance is considered a breach and allows the landlord to terminate the lease. And then you may be held liable for damages for early lease termination. Another technical matter that often accompanies insurance clauses in commercial leases is the waiver of subrogation. Failure to ensure that this waiver of subrogation is included in your commercial lease can have serious consequences. So the word subrogation means to step into the shoes of another to enforce claims of another party. Let's say, for example, you are a tenant renting a space to sell smoothies. A pipe burst in your shop. The landlord's insurance company covers the cost of repairs, but then that insurance company turns around and then sues you for the amount of money that they spent out to repair the busted pipe. Even though in most cases, as a tenant, you're most likely contributing to the cost of that insurance through your rent or your common area maintenance expenses. This is why you want to look for that waiver of subrogation. Either you want the landlord and its insurance company to waive claims against the tenant, or you want a mutual waiver of subrogation where both parties waive claims against each other. Number 11 is defaults and remedies. In a commercial lease, a default describes the ways that each party can breach the lease agreement. I have other videos that further explain breaches, but basically a breach is a failure to uphold an obligation in the agreement. A breach can occur from either the tenant or the landlord. However, in most cases, the default provision will favor the landlord. So here's what you need to look for concerning defaults in your commercial leases. Number 1, you need to look for a provision that states that a failure to do something constitutes a major or material breach or default. An example is something like failure to pay your rent by the 4th day of each month is considered a material breach. This is important because the law provides different remedies for a major versus a minor breach or default. Number 2, you need to look for the type of notice that is required to be provided in the event that a default occurs. You may see a provision that states if party A fails to do this, then party B has 30 days to provide written notice to party A. Using the example we used earlier, if the tenant fails to pay the rent by the 4th day of each month, the landlord will provide a 3-day written notice. Number 3, you need to look for the opportunity and the timeline for the defaulting party to cure the default after the notice is provided. So this may read something like the tenant shall have 10 calendar days after receipt of the landlord's 3-day notice to pay the rent in full plus any late fees. And number 4, you need to look for the consequence of the failure to cure the default. So this may read something like, if the tenant fails to pay the rent and all late fees within 10 calendar days of the landlord's written notice, the landlord shall terminate the lease and the tenant shall surrender the premises. You following me? You see where I'm going. Additionally, you need to look for any contract provisions within your lease that determines what remedies are available to you if there's a dispute between you and your landlord. You're looking for clauses that state whether the winning or prevailing party will have to pay the other party's attorney's fees if this action goes to court or some other dispute resolution. These are all major considerations that will be outlined in the remedies section of your lease agreement. Okay, 2 more and we're done. Number 12 is indemnification and exculpation. Just a few minutes ago, I talked about whether the landlord has limited their liability. And in all cases, I have never not seen a party not limit their liability to the extent that the law allows. One way that a landlord can limit its liability is through an indemnification and exculpation clause. These clauses dictate who will be responsible for injury, damage, or death that occurs on the property, regardless of who is at fault for the accident. In an indemnification provision, one party agrees to be responsible for the injury, damage, or death of another person on the property. Again, regardless of any negligence, regardless of whose fault it was that caused the accident, as long as there was no gross negligence or willful misconduct. In an exculpation provision, one party waives any personal liability against the other party. Those are important terms to know. All right, and last but not least, let's talk about number 13, the termination clause. With termination, I'll just say make sure that you review your lease agreement for terms regarding early termination to include penalties and notice requirement. Additionally, make sure that you review your lease agreement for ways that your lease can be terminated involuntarily, either through eminent domain or changes in the law, or if your landlord is bought out by a third party or another company. Understanding these aspects of your commercial lease will help you make a more informed decision, and it may help you secure better terms that are more favorable to your business. Well, that's all I have for this video. I hope that this information was helpful to you. Don't forget to like, comment, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye.